You're watching the Open Debate on Mirror now. Faye D'Souza, good evening and thank you for joining us. Now, this was a judgment we have been waiting for over a year, for the Supreme Court to give us its verdict, and now it's given us its verdict. Now, just to give you a quick wrap of that verdict before we start our conversation, it was a 5-judge bench. 4:1 have agreed that Aadhaar should stay. Justices Sikri, Dipak Misra, Kanvarikar, in the majority judgment, put out some very, very clear points, and I'm just going to go through what those points are. The Supreme Court is first of all satisfied that there is no possibility of the Aadhaar Act turning into or allowing for a surveillance state, that the government has adequately created security features to keep the database safe, that there is no room for misuse, for hacking or for duplication of the Aadhaar data, that the Aadhaar Act does not violate our right to privacy and balances it quite well with the right to food, shelter and employment. Also points out very clearly that children under the age of 18 do not need to get Aadhaar cards unless and only with their parents' consent. It also maintains, and this is the important part, the purpose of the Aadhaar Act and Aadhaar in general is to make sure that beneficiaries receive benefits from the government after being properly identified. Now, here's what is the operative part for you and me. Aadhaar will need to be linked with PAN cards. That continues with income tax returns as a result of PAN cards, and with welfare schemes and subsidies. Aadhaar will not be needed to link to bank accounts, to new or existing bank accounts, to private entities like telecom companies, e-commerce firms, your SIM card, your cell phone, shopping online, admissions for schools, any sort of examination, whether that is CBSE, UGC or NEET examination. So that's where we stand right now, but there were a lot of tiny and large intricacies in and nuances in that judgment that we need to take a closer look at, and of course so many questions to answer from our viewers that have come in through the course of the day and are still coming in right now. I have a brilliant panel of legal minds joining me at this moment. Sanjay Hegde, Senior Advocate with the Supreme Court. Geeta Luthra, Senior Lawyer with the Supreme Court. Kailash Vasudev, also Senior Advocate with the Supreme Court. Pavan Dugal is a cyber law expert and an advocate with the Supreme Court. Vinay Tiwari, Consulting Editor with the Times Network. Mr. Arima Sundaram, Senior Advocate with the Supreme Court. Siddharth Luthra, former Additional Solicitor General. I'm extremely pleased to have such a brilliant panel. Thank you so much, all of you, for giving us time here on Mirror Now this evening. Thank you for making time for us. A couple of the questions that we need to dive into straight off. And the first one would have to be the question of the money bill. And that's something I'd like to target head on. The fact that in the majority judgment, and our viewers will remember, the Aadhaar Act or modifications to the Aadhaar Act were brought into Parliament as part of the money bill and were passed without discussion. This was challenged in court, and the court has now believed that it was fair that it be moved as a money bill. I want to understand if this will now give the government a lot more room to bring in other perhaps laws and amendments that will look a little bit like the Aadhaar Act, because up until now it was only the union budget that was moved as part of the money bill. So let me start with Mr. Sundaram. Arima Sundaram, the money bill decision, does this leave a wide window now for the government to bring in other sort of acts as part of the money bill?
Well, I would say so. I haven't really gone through the judgment in such detail as to see whether any yardsticks have been laid down, guidelines have been laid down as to what exactly can be a money bill. But obviously, what can be brought in as a money bill has been expanded. It's been made more elastic in allowing the Aadhaar Act to come in as a money bill. Let's understand one thing. The important fact of a money bill is, at the relevant time in this case, for example, the government did not have a majority in the Rajya Sabha. The advantage of the money bill is that even sans such majority in the Rajya Sabha, you are still able to enact the particular legislation. Now, bringing it in as a money bill has therefore got its own ups and downs. And that was the downs are what were commented on in the dissenting judgment of Justice Chandrachud in saying it's a way to circumvent Parliament from fully addressing themselves to it. But given the fact that the majority feels that the aspects of the Aadhaar Act are such as to justifiably be brought under a money bill, we have to go through the judgment to see what guidelines have been laid down for that purpose. There is one other important takeaway, though, on this issue. Till now, the basis of legislative action has been that the Speaker's decision on whether it's a money bill or not is final. Now, it has been made clear in this judgment that that decision as to whether it's a money bill or not is justiciable through judicial review. And I think these are two takeaways we have to take from that aspect of the decision.
To my esteemed panel, please, if anyone wants to come in at any point, let me know that you have a point to add. But Mr. Sundaram, for your benefit, on page 562 of the judgment, it says clearly that since the money bill has to do with the consolidated, with funds or benefits that will be withdrawn from the Consolidated Fund of India, and the Aadhaar Act applies to, to subsidy that will be withdrawn from the Consolidated Fund of India. Therefore, the main purpose, given the main purpose of the Aadhaar Act being related to such subsidy and benefit, this is why it applies. Vinay?
Yes, so they have interpreted this, and I think Mr. Sundaram was right.
Absolutely, that's why I said it's been made more elastic, that it's been made more elastic now. That's why I said that.
Yes. Sanjay Hegde? Is this now this elasticity doesn't leave for a loophole, Mr. Hegde?
The elasticity has been described as a fraud on the Constitution by the dissenting judgment, and I'll tell you why it's a fraud. Tomorrow, anything could be justified as a money bill as long as you have the Speaker certifying it. Let's take something like the Citizenship Act, for instance. There's an amendment proposed, there are problems with it. Now, if you adopt an elastic definition, and the Speaker certifies it, that citizens will necessarily receive benefits and subsidies from the government, and it will involve expenditure from the Consolidated Fund of India, then almost anything can be justified as a money bill. Someday a court will have to review this part of it. A constitutional fix or a bit of a jugaad sometimes is okay. But if you run a coach and horse through the Constitution, it is going to come back and bite you as a nation someday.
Yes, in fact, I'm going to ask this panel for a very simple question that I'm sure a lot of our audience is wondering at this point. This was a 5-judge bench. The first, what we're calling the majority judgment, was the judgment, a unanimous judgment between 3 out of those 5 judges. And then we had what we call the dissenting judgment from Justice D.Y. Chandrachud, which was in almost nearly complete opposite of the first one we heard. And the last one wasn't so much, was largely in agreement with the first one as well. So what happens to the points made by Justice Chandrachud, for example? Geeta Luthra, if you could help our audience understand this, because he said some very interesting things. I mean, he began by saying that the whole thing is unconstitutional and should be wiped out. And then he also said that, telecom companies, for example, who've collected data should be made to delete it. Now, does none of this apply at all? What will these statements be used for? Could you help us understand what that dissenting judgment can be used for, and how does it apply?
So the dissenting judgment is an interesting and an important point of view. It basically tries to say that the right to privacy cannot be infringed in this manner, and that there are not sufficient safeguards, there are loopholes, and there's scope for violation, and that's one aspect. With regard to the aspect of it being a money bill, he disagrees with that. Now, what can it be used for? History is full of judgments where a dissenting judgment has subsequently become the law of the land. And this, I think, would be an aspect which Justice Chandrachud or the court would look at, that there are these 2 viewpoints which are possible. The viewpoint that the Aadhaar bill is a beneficial legislation, is a money bill, and therefore could have been passed as a money bill, and the other aspect that no, in fact infringes the right to privacy, and in terms of the Puttaswamy judgment, the court says that according to Justice Chandrachud, this should not be permissible because the Aadhaar Act as such is in fact impinging on the right to privacy of individuals, which the courts have held very recently to be a very real right. So I think that's what it is. So it's got its importance and it will have a place in history. Posterity will tell whether that may become the future law at one time.
Well, that's an interesting point. Vinay, one of the things...
Faye, if I could just come in for a minute.
Yes, Sanjay Hegde, please go ahead. Please go ahead.
Faye, there was a US Supreme Court Chief Justice who had something to say about dissents. Charles Evans Hughes said a dissent should be an appeal to the brooding spirit of the law, to the intelligence of a future day. As Gita said, many a dissent goes on to become the correct law of the land. In Justice Chandrachud's father's case, Justice Chandrachud Senior in ADM Jabalpur said that your right to life could be suspended during an emergency. Justice Khanna dissented. Today Justice Khanna has universally been held to be vindicated, and it was in the privacy judgment itself where Justice Chandrachud Jr. also joined the others in burying the ghost of ADM Jabalpur. Today, Justice Chandrachud Jr. has reincarnated the spirit of dissent, an appeal to the brooding spirit of the law and to the intelligence of a future day. One more example. In the 377 judgment, a bench of 2 judges said that these are concerns of a minuscule minority. Very recently, a constitution bench of 5 judges said that those 2 judges got it wrong.
Yes.
Today, the judgment of the majority, I believe, will not stand the test of time.
Siddharth Luthra is with us as well. Mr. Luthra, do you agree with Sanjay Hegde?
On an intellectual plane, yes, Sanjay's got a point that dissent is often becomes a way for the future, but we must look at this slightly distinctly, because as I note in para 406 of the judgment, the counsel for the petitioners themselves had said that section 7 of the act has the elements of a money bill, and it was only certain other provisions that they sought to attack. So let's keep that in context while having this discussion, because that is also a context that needs to be said. Having said that, when judges decide matters, and these are opinions which vary because you have your own intellectual viewpoint, Justice Chandrachud has taken a dissent. He believes that, and he's said in very strong words, it's a fraud on the Constitution. 3+1 judges have taken a different view. This question whether Justice Chandrachud is right or not is to be tested with posterity, or whether the majority is right or not. I think today the statement of law by the majority is the law as it stands.
Yes.
And we will wait for a future date to see whether it's overturned. Even in the context of privacy, there were attempts made from the 1960s, Justice Subbarao's views that privacy is a right, but it was never recognized till the 9 judges bench recognized it. So these are evolutions within the law which take place over a period of time, and while a certain viewpoint is right today, it may change, and that's something to be seen in the future.
Well, Vinay, we do know that the Congress party has said that they will go back again and appeal one more time as far as the money bill matter is concerned. And one of the petitioners has said that they will make a review petition as well, right? So there's a possibility of some of this being relooked at.
A dissenting judgment does sometimes form the basis of a review or a curative petition that can be filed at a later stage. There is one other point, Faye, since we spoke about the dissenting judgment of Justice Chandrachud, which is very important. One of the grounds he took for calling it unconstitutional was that his logic was that under the Indian Constitution we have a bicameral system of politics, And Rajya Sabha, the role of the Rajya Sabha is enshrined in the basic structure of the constitution itself. Now, if you allow the Lok Sabha speaker to take as he called it, an arbitrary decision on deciding which one is a money bill and which one is not, you are undermining the bicameral nature of our constitution itself. And hence, this is undermining the basic structure where you necessarily must have a situation where a money bill can and only be under the 6 provisions that have been specified in the constitution, and there cannot be any other exception unless any or all of it satisfies that. So he does in many ways question this decision as an attempt to bypass the bicameral nature of Indian politics.
Yes, and he said some very strong things, and and this is why I believe.
In fact, I must add here.
Yes, Mr. Luthra, go ahead, please.
If I may, it's not that Justice Sikri has not dealt with this aspect. Even the majority has dealt with the same aspect. The majority has emphasized the importance of the Rajya Sabha and the bicameral nature of our legislature. But at the same time, the majority has looked at the legislation closely, not that Justice Chandrachud has not, and found that the kind of welfare measures proposed under this legislation, if kept distinct from the chaff which has now been struck down or read down, that is clearly in the nature of a money bill, and therefore the majority has upheld it to be a money bill and cleared it. And that is the test. So that the question is really, the debate has been the same both sides, but the conclusions are different, and that's something we must understand. So far as the review is concerned, of course people have a right to file a review on this, and of course people have a right to even take it up to a curative petition. That will be determined depending on what is an interpretation of the law is put forward.
Right. I want to move to other portions of, of the judgment. So, for example, if we just talk about data protection and security, the fact that does the Aadhaar Act and the rule, does it respect the data? The majority judgment was very clear, categorical, in fact, about the fact that the actual Aadhaar system per se is impenetrable, that it cannot be hacked, it cannot be compromised, that it is in fact, the biometrics in fact leads to unique numbers, and there's no duplication here, and it cannot be misused even. So the 3 judges there were very clear, although again Justice Chandrachud was in complete disagreement of it. This sort of puts to rest, does this put to rest a lot of the questions that we had been asking up until now? And this is my question, if I may, for Kailash Vasudev. Mr. Vasudev has been part of a lot of the discussions we've had on this channel about data security, about the authenticity of the data that's been collected, the integrity of the data that's been collected, Mr. Vasudev. Are all of those conversations now behind us?
Yeah, first I must thank you for the enormous effort you put in on this channel for the purposes of discussing Aadhaar, culminating in a judgment which is not in your control. Let's come to the judgment per se. There are 2 aspects which personally I feel need to be relooked at. The first is the money bill aspect. You see, a money bill deals with the apportionment of money from the Consolidated Fund of India. In this case, not everybody benefits from the apportionment of the consolidated fund. It's a benefit given to a small section of people, maybe a large section of people, but it is not for the entire nation. Because the act by itself says benefits to those who need it. If it is a limited benefit extended to a limited number of people, classifying it as a money bill becomes a very questionable issue, which has partially been touched upon by Justice Chandrachud in his dissenting judgment, but has been glossed over in a big way in the main judgment. I say glossed over because you refer to the consolidated, you read para 423, there are other paragraphs also, where they define this to be a money bill. A money bill is a very specifically defined bill under Article 110 of the Constitution. Everything which happens in a money bill touches upon the funds of the Government of India, especially the Consolidated Fund, which is again a defined article. Just because benefits are to accrue or benefits are to inure to a group of people, I have my reservations, I use the word I deliberately, to classify this to be a money bill. Money bill, the whole situation will then change. Sanjay Hegde just mentioned the consequences of opening up a debate on money bills. Money bills are specifically defined in the Constitution for the purposes for which they're enacted. Coming to your second issue, whether this data is sacrosanct, whether it can be touched or not touched, or it can be interpolated, played with, hacked, etc. No electronic system guarantees you this. Justice Chandrachud in his dissent has dealt upon this in a big way. The majority says, no, we'll take what the Attorney General says and what the Government of India says. If you're going to accept one side of the picture after seeing so many incidents which have taken place, there will be a bit of a difficulty in case there is a hacking. How will you do it? How will you tackle it? I don't know. Another aspect which arises here is, assuming that somebody comes and says that my account has been tinkered with or hacked or played around with through the PAN system, what is going to be our answer to it? Because the Supreme Court says, follow the PAN, PAN will have the Aadhaar card, indirectly you will have everything extending into the PAN. Once you have the PAN available, you've defeated the purposes of the Aadhaar. If you're going to defeat the purposes of the Aadhaar indirectly by supporting PAN, in view of the earlier judgment of Justice Sikri, what is going to happen is the PAN now becomes the center. Aadhaar is given a go-by where anybody wants to get your information. Right to privacy, your individual rights, there's a right of apportionment and all sorts of things have been discussed in the judgment. Even those really don't answer the question about what would happen if PAN information is made available. Moment PAN information is made available, your Aadhaar card gets disclosed. So the view of Justice Chandrachud is what I support, because that says that freedom is absolute. The other judges, the majority judgment, has taken a view which to my mind needs to be relooked at some point of time in history, because you have a 9 judges judgment on privacy. You have disagreed with it in one sense that no, Aadhaar does not impinge on this thing, and it is not a surveillance situation. It is not a surveillance situation because certain things don't go into Aadhaar in view of their interpretation of Section 7. Banks, telephones, etc. don't go into it. But how do you come to an answer and balance the PAN card situation vis-a-vis the Aadhaar system?
All right, I'm opening this up now to the rest of the panel along. Pavan Dugal, as a cyber law expert, your quick response as well, Mr. Dugal, on this whole, data protection laws. Now, the Supreme Court has asked the government to come up with strong data protection laws, and the idea that that the Aadhaar data is secure. The court is satisfied that the data is secure. Mr. Dugal.
Well, as a person working in this field, I would tend to disagree with the thought process that the data is secure, because the concept of data being secure is a utopian concept. There's nothing called complete security of the data. What was secure yesterday is not secure today. And what is secure today will definitely not be secure tomorrow. So when you come up with a judicial pronouncement which effectively endorses a stand on security of a particular party, that actually sets up pretty dangerous precedents, primarily because security is a constantly moving target. So the fact of the matter is, if Aadhaar is so secure, and if the majority judgment believes it's so secure, then what is the logic of all these cyber security breaches that continue to keep on happening on the Aadhaar ecosystem? As per UIDAI's own admission, last year, UIDAI landed up actually registering more than 50 FIRs for cyber security breaches. So if the system was so robust, so secure, so sacrosanct, where is the question of these FIRs being registered? Also, by giving a kind of a stamp of approval on cyber security of Aadhaar, when the entire ecosystem is completely not secure, I think we are actually walking in a wrong direction. Because now, please understand, ever since that open challenge took place of Aadhaar being secure and not secure by the former TRAI chief, now that started up a community kind of a revelation. The community of hackers walked up together and say, hold on, let's accept this open challenge and let's now try telling you how Aadhaar is secure. Forget about things. For 3 weeks back, we find these numbers of the UIDI, or this helplines, all emerging on our phones when none of us had actually put the same. So I think it's dangerous precedents. I personally believe that the scenarios that have been put up in the minority dissenting judgment are very, very serious. and real scenarios, and they would require appropriate adjudication by a larger bench at an appropriate point of time. But clearly, these kind of incidents are not only going to push the UIDAI into complete complacency, that they now have the stamp of approval of the Supreme Court on their privacy, on their security, and they would not want to move forward. Also, considering the fact that cybercrimes are constantly enhancing, and also the fact that the Aadhaar Act does not give us any effective remedy once your biometric information gets compromised, I think we have to look at these entire things pretty much more in a holistic perspective, that too at a time when India does not have a dedicated data protection law, that too at a time when India's national cyber security policy of 2013 is completely silent on the security
and at a time
of Aadhaar
when the UIDAI argued that part of its protection was a 13-inch wall. A physical wall outside of the database center. These were some of the arguments that were made before the court. Vinay?
Yes, just one thing, Faye and I, this is a slightly dissenting note, and I think we have probably slightly been a little harsher than what we should have on this aspect. I don't think, if you read the judgment, it's not as if they're saying that this is completely secure in posterity, in future. They haven't said that at all. What they've said specifically is that we are satisfied that Aadhaar as a structure does not create a surveillance state, but they have recognized that there are inherent dangers in what your procedure is, and hence they have read down certain provisions. For instance, one of the key things that they have read down is that so far the law allowed the data storage for 5 years. They've restricted that to 6 months. Your authentication records can now only be kept for 6 months and not 5 years. That is one. Plus, they've also added a few other technical aspects. The metabase relating to the transaction, that has been removed. There is a suitable amendment they've asked for. They've asked for an amendment of section 33(1). They have also, because what Pawan was saying was right, they have insisted that the government must now ensure that a data protection bill comes out in a robust manner based on what Justice Sri Krishna has said,
but it
because
also,
they recognize
yes,
that.
but it also says that the said encryption is almost foolproof and is virtually impossible to decipher the same. Adoption of best-in-class security standards and practices, strong audit traceabilities, as well as fraud detection. Above all, the oversight of a technology architecture review board. So there is a certain amount of faith
the only surprise for me, Faye, was that the judgment seems to have relied very heavily on the
If I may add here.
Yes, yes. Mr. Luthra, please go ahead.
If I may add here. You know, we need to understand what was the test here. The test here was a law. And the mechanics of how the law works out is another issue, since that got argued at length as to how the law will lead to aberrations and how there are gaps in the mechanics of the working of Aadhaar. That has led to a certain amount of debate. Now, I agree with Pawan, there is no system that can be absolutely secure, but then it's like the banking system. Just because bank frauds take place, won't you regulate it? In fact, when you take people's data, and here data has already been collected, what is needed and what the court has also opined is a strong, robust system to ensure that there are no data breaches. As on today, the court, consisting of lay people and not technical people, people who understand the legal aspects and try and understand the factual aspects with different sides, different warring sides trying to place a picture, have accepted a certain view on the current robustness of the system. Pawan says it's not robust enough. Yes, he's got a valid point. These are technology is an ongoing process and we have to keep meeting the technology challenges of the future. But that doesn't mean that there was not a need to regulate it, and the court today says regulate it better. So I really don't see that the aberrations in the operationalization of Aadhaar can be used to strike down a legislation. That, according to me, was never a ground, cannot be a ground.
All right. And you know, we have questions coming in right now. Someone's written in saying, what about...
Luthra, I have a bit of...
Faye.
Yes,
Faye,
Arifa Sundaram, please go ahead. Mr. Sundaram, go ahead.
Faye, if I may say something here.
Yes.
Look, Faye, I really believe that we've got to accept one thing. There's a very old saying that a hammer forges steel but breaks glass. Without a doubt, technology, howsoever advanced it is, there is always the hacker for every system, however great the system is. we have to somewhere along the line say, yes, technology gets us a lot of advantages. At the same time, there are a lot of disadvantages which can come out of it being hacked or cracked or anything else. So basically, I think what the court needs to look at, and what the court has really looked at in this case, is that overall, is the idea of having an identification card like this, is it for the positive on the whole, or is it negative? The court has come to the conclusion that on the one hand, to have a card like this, to have a system like this, to have the Aadhaar, you are going to be in a position to reach people who need help and sustenance. It gives you an avenue to reach them in a much better way. And that gives an opportunity for them to live a life of dignity. The court is not blind to the fact that, yes, privacy is also going to be affected to some manner, to some extent. But what the court says is, when they view the two conflicting fundamental rights of dignity and the right to privacy, certain restrictions on privacy can come about if it's for the overall good of dignity. Now, we can sit and we can dissect this. I am telling you that any system which you come up, you will always have somebody who finds a way to hack into it to do something. So to assume that this can never be hacked is being simplistic. What the court has looked at a larger angle is to say, is it a system which, if it has the sufficient safeguards, is the system in place sufficient to ensure that there can be safeguards against such indiscriminate sharing of the information? And they've looked at it in a more macro sense. The reason being, the judges who are sitting on the case are not technological experts who are going to be able to comment on it. There has been a technological team which has decided on it, which has presented a case, and the court somewhere cannot itself become legislator, come judiciary, come technology experts, or everything else. The court always says we rather leave this to experts. The court is satisfied that enough effort has been put in to safeguard this, and that seems to be the way to go. Today, if you're going to have everyone turn around and say this system can be hacked or that can be hacked, of course it will be. So let's not use technology at all. That's not the answer also. The answer is, what are the advantages of this Aadhaar? And if the advantages are such, then let's go ahead with it, even... sorry.
I want to introduce a new question to this panel, right? Yes.
Faye, if I could respond.
Bring in a robust system in place that can ensure that.
Just one second. There is a question we've received all afternoon, and I know Sanjay Hegde, you will want to answer this question, and I want to pose it to this panel, and the question is this: what happens now to all of the linking that has already been done to the bank accounts, to the cell phone companies, to the insurance companies, car insurance companies? Almost everyone who met you on the street wanted you to link your Aadhaar to some sort of business service or the other. I mean, Reliance Jio's entire telecommunications subscription model was based on give us your Aadhaar and your thumbprint. So how do you unlink? Sanjay Hegde, is it possible now to check out of this virtual Hotel California at all? Will this data, like Justice Chandrachud has advised, should be deleted? Will it be deleted? Is it possible to delink? Is it possible now to delete all of that Aadhaar information that has gone out? And this is to the whole panel, but I'll start with Sanjay Hegde. Sanjay Hegde, please go ahead.
That's precisely what has happened. This has become too big to fail. This is the too big to fail argument. This data, once it is out there, it just cannot be deleted. And even if any commercial organization tells you, yes, we have deleted your data, there's just no way to check. It is only when, as a consequence of that data being misused by someone, that something criminal happens, maybe you could take effective action, at least against those who are responsible for disseminating the data into hands which were not meant to have them. But the Aadhaar system has in all ways been leaking. It has been the data has been indiscriminately given to all kinds of people. The number of hacks which have come out in the public domain are huge. Essentially, I believe that this judgment will collapse under the weight of its own contradictions, and Aadhaar itself will become such an instrument of oppression that it will become politically unviable. The fight has not gone out, the fight will continue.
May I respond, Faye?
Yes, just one moment. I want to give Geeta Luthra an opportunity to respond because she's been very polite and she's been listening this entire time. Ms. Luthra, go ahead, please.
So the first aspect I want to say is that I don't think the Supreme Court should have said that we believe the Attorney General that a data protection bill or an enactment or law will come. I think that law should have been in place earlier and then you test the veracity of the act. Because we can't just rely on the state to do this. Now it's become all pervasive and I feel there should be a machinery to test that it can't remain all pervasive. So having said that, I feel you can't put the cart before the horse. You can't say the act is good and the state will have methods in place or checks in place to ensure that there is no abuse. That's the fear, and I think that's the fear which all of us have in today's day. And that fear the state has to, or the government has to. The attorney has said so, they have to act on it quickly before they actually start acting on the Aadhaar enactment. That's what I feel is so important.
Can telecom companies be compelled to give us our data back?
Look, the fact of the matter, Faye, I want to say something which is very relevant here.
Yes, please.
I quite agree. I really can't understand how this data is, we can rely on this data coming back. I really can't see that, how it's going to happen. But I want to say something. I don't know whether one is aware when looking at the fact that the judgment has actually upheld constitutionally the Aadhaar, struck down provisions saying that it cannot be given to private persons, it can only be used for certain people. Now, I have one point to make here. I think the government has really succeeded in this entire case because looking at it practically, Aadhaar has become mandatory for most of the population, and I'll tell you why. For those who are impoverished and who account for a majority of the country and who require the welfare schemes, they have to have Aadhaar. You want subsidized LPG, you have to have Aadhaar. Now with the widening tax base, anyone who's an income taxpayer has to have the Aadhaar card. From what I've understood, even a driving license may require the Aadhaar card. I ask myself, who is left out of having to mandatorily go in for an Aadhaar card? So much has been said all day and I've been hearing this saying, look, there are a lot of places the private persons don't have the card. You don't need it for banks, you don't need it for schools, you don't need it for education. Yes, that's all very good. But the fact is, sooner or later, most of our population is going to mandatorily require this Aadhaar card because either they are too poor to pay taxes or they are wealthy enough to pay taxes. If nothing else, they may not be paying taxes, but they'll at least need a scooter or a motorcycle. So when you look at it that way, I really believe that the government has succeeded, and let's accept that, in bringing in Aadhaar today. Now, once Aadhaar has come in and the Supreme Court has felt that the advantages of Aadhaar outweigh the disadvantages, the next step is, yes, a robust system has to be in place now to ensure that the damage is minimal. That's why I said, I likened it to the hammer, which can either forge steel or break glass. And this is a fact. But the court has really viewed the two, seen what has to be done, weighed the advantages and disadvantages, and said, look, in this case, the public interest, the advantages are more. And I don't know whether I disagree with that, because according to me, there are great advantages if you're able to really implement the welfare measures. And I think that is something we have to keep in mind. And yes, privacy is going to be affected to an extent. But the question is, somewhere or the other, there are always conflicting fundamental rights, conflicting rights of people, and one weighs it. Now, all I'm saying is the court's approach to the whole case has been from trying to see and work out a balance. And I believe it's worked out the balance to the best of the ability that the court could. And that's my way of looking at the judgment.
Here's my quick question for whoever wants to answer this one. The court has said that Aadhaar will be used compulsorily only for those people who are seeking a benefit or a subsidy from the government. It has also said that nobody will be denied a benefit or a subsidy from the government for want of Aadhaar. Now, how do we reconcile these two? So let's assume I walked up to my ration shop and I don't have my Aadhaar, or my details are not matching at this point. Obviously, at this point, the ration shop owner is going to deny me the ration that I have come there to take. So how do we make sure that I don't get denied?
The details don't match, not having an Aadhaar card.
Kailash Vasudev wanted to answer. Mr. Vasudev, go ahead.
Let's correct one thing, Faye. My understanding is that's if the identification doesn't match, not if you don't have an Aadhaar card, but it doesn't match.
But it's compulsory for those who want subsidy. So then, is not having an Aadhaar card a viable excuse? So. Mr. Vasudev, go ahead, please.
That's right. See, the position is this. Aadhaar has been made mandatory for those who are taking benefits from the state. It has been mandatory to link up to your PAN card. So these are two things you have to keep in mind. If a person does not have a Aadhaar card and goes to get his rations or subsidized stuff, he cannot get it. That's the rationale behind the act. On the other side, the rationale behind the act also provides, and the Supreme Court upholds it, that the data may be given to somebody else for commercial purposes, excepting the biometrics. That's section 27 or 28, whatever. Now, if you're accepting the fact that data can be passed on, if you're accepting the fact that rations or benefits can be given to those who don't have an Aadhaar, these become inherent contradictions. Taking a view which says Aadhaar is mandatory would have been different. Taking a view that Aadhaar is partially mandatory again makes the whole situation fluid. Once you have a fluid situation in the law, you have a fluid situation on the ground. The majority says that, look, we need the Aadhaar because we've got to get our rations, we've got to subsidize, we've got to get our subsidies. The minority, who are the major taxpayers of the country, say, why should we link up with PAN and Aadhaar? It doesn't apply to us. So these are contradictions which will have to be dealt with at some point of time. Either government does it, because the Supreme Court today is ruling everything, right from Aadhaar down to triple talaq, down to your rights, down to everything. If we are leaving it to the court to decide, then let it have its full detail before it comes to a judgment. Saying technology is good, it can be improved. You see, these become contradictions in a judgment which do not show the whole situation in good light. That's my view. Now let's expand this a little bit. We had cases in Ranchi, we had cases in Jharkhand where people didn't get the rations and they died because they couldn't get the rations and they didn't have an Aadhaar card. If you recall that. Now, if you're going to have those kind of situations to which there is no answer, what happens if an Aadhaar card doesn't work, if a system doesn't work, the person suffers? Who's going to be sued? Who's going to protect their rights? You know, these are issues which should have been addressed either by arguing counsel or by the state. No one has addressed this aspect of it. Failure of Aadhaar per se for an individual costing a life is a matter of grave concern. You have had the situation in the Tribune reports, if you recall, where everything was exposed. You've had cricketers whose names were exposed as Aadhaar card disclosed. You see, these are areas which technology has failed. Therefore, the court says improve on technology. But what do you do about the present? I mean, these are doubts to me because I personally feel
there are several questions.
For those of us who are honest taxpayers, and most of our panel members are.
Yes, Mr. Vasudev. Yes,
are paying taxes. Why should we?
Yes. So we did have the judgment today, and there do seem to be a lot of questions that still arise as to how this judgment will be applied and what happens going forward. We're going to stay with the Aadhaar judgment after this very quick break. We also have Harish Salve join us live here on Mirror Now to give us his view and his understanding, and we'll continue to take questions. We'll open up the phone lines immediately after that, right through 9 p.m. up till 10 p.m. So don't go anywhere. Stay with us. Quick break.